blank, any
Oh,
blank contracts,
any what?
blank contracts?
Oh, yeah, we're gonna do that, but that would be week 5. Is that what you're talking about?
Yeah, so then, yeah, because I wanna get a blank contract. If you have it,
Oh, you just text me and let me know what blank contract you need, and then, you know, I'll email it to you, Oscar.
great, thank you very
Okay?
much.
Yeah, no problem. Okay. So, yeah, so let's get started on the top of page 4, property addenda and advisories. So addenda and addendum, addenda is plural for addendum, is contractual terms, while advisories are informational purposes only. So what's nice about this newer, it's not new, but newer, or RPA, is they've made it so that we can use it on multiple property types. So once you get down where all of the items are on this RPA form, you can make it into a probate agreement with the purchase addendum attached, a manufactured home purchase addendum, tenancy in common, a TIC purchase addendum, stock cooperative purchase addendum. So it's a really great thing that we can just check the box and it becomes that type of purchase agreement. And that's why it's really important. We all do our best to read through this contract and understand it to the best of our ability. So here you'll notice that they have the tenant occupied property addendum, which is the TOPA we talked about last time. So when you're writing an offer, buyer's agents, you may not know if it's a single family home, if there's a tenant there. So you may not have checked this box. But if you get a counter back and there's tenants on the property, or they're disclosing that to you, make sure that you get a fully executed tenant occupied property addendum. As we said last week, there's a lot of protection for everybody on that. So buyer's agents, you might not be checking that out the gate, but if you get a counter that tenants are staying in possession, make sure you get that. Now, this tenant occupied property addendum TOPA is also relevant if they are leaving by close of escrow, the tenants, or for those that maybe there's relatives in the property that aren't paying rent. So it's also for non-rent paying tenants as well. Okay, so now we're going to come down to other addenda, excuse me. So if it's applicable to your transaction, you can check any of these. So maybe you want to attach an addendum with further information in it, backup addendum, septic well. If that's the case, then you need to check this. Now, I've highlighted some of the newer ones, the buyer intent to exchange and the seller intent to exchange. These are nice forms because it outlines the whole exchange process and the time frame. So make sure that if I know we can put, you know, in the bed in the financing that the buyer intends to exchange, but if you do that, make sure that you're also attaching the buyer intent to exchange form. Now, if a seller merely counters and doesn't provide you with the intent to exchange addendum, make sure you're asking for that as the buyer's agent. Court confirmation addendum handles things like divorce, bankruptcy, conservatorship, guardianship, things of that nature, and other legal proceedings. Okay, so now here you have buyer and seller advisories. So these are pre-checked, these advisories, so they're going to auto-populate with your offer. So just bear that in mind. These will already auto-populate, so everybody just signs them. The BIA, Buyer's Investigation Advisory, has a lot of good information. You may want to go over it with your buyer regarding some items that they can be aware and check for when they're in their contingency period for the property. So trust advisory, if you're writing an offer and a trustee signing, go ahead and attach the trust advisory, REO, probate advisory, or short sale. Now I've highlighted statewide buyer and seller advisory. That is required by our brokerage as part of our disclosures. But a lot of times we're not checking it into the offer because it's a 14-page document. It's very big. So you usually don't check it into the office, but offer, but I wanted to make you aware we do require it, but that's entirely up to you as an agent if you check it in or not. It's just a lot of paper. Okay, so moving down to the initial deposit, as we talked last week, the initial deposit.
I'm sorry, Michelle. What would you recommend? Do you recommend we include those 14 pages in the offer, or no?
Rosie, for me, I've never included it. I mean, I don't recommend it because I think when you're sending an offer and it's, you know, already long enough at 16 pages plus the pre-attached disclosures or advisories, excuse me, it just makes it huge. So for me, I do not include it at all. I never have.
Okay, thank you.
Unless a buyer or a seller is adamant that it be included, I just don't include it. But I do catch it later because it's a requirement, you know. So thank you. That was a great question. So
Michelle?
Yes.
Hey, Michelle, this is Sylvia. But at the same time, when we submit an offer, normally the seller's agent will include it when we, as the buyer's agent, are have been accepted, right?
Well, okay. So usually it's gonna, like, so if a seller's agent counters you, they're normally not going to counter in the statewide. However, they are going to include it. And I think this is what you meant, Sylvia, that will be included in their disclosure package.
Correct.
If it's not, then you can prepare it, have your buyer sign it and send it over to the listing agent for the signature of the seller. Yes.
Correct. Thank you so much.
Oh, of course, you're welcome anytime. So the initial deposit, as we talked last week, the method of deposit defaults to a wire transfer, and the method needs to be acceptable to the escrow holder. So if you check the other box and put personal check or money order, and the escrow company does not deem that acceptable, then it will revert to a wire transfer. So notice from the escrow holder that they want that deposit delivered via wire transfer, then you need to do that, just so you understand. Usually not a big problem because, sorry, lost my sheet. So on the wire transfer, normally there's no issue in that. Just make sure that you're going over that wire fraud advisory with all the clients, okay? So increased deposit, as we discussed last night, if you have checked for an increased deposit in this offer, you need to supply CAR form DID at the time of the increased deposit, delivery of increased deposit, not with your offer, not with a counter offer, but at the time you are making the increased deposit, have that form fully executed. So what this form does is, if we've all signed, buyer and seller have signed liquidated damages further back in the contract, there is a checkbox on the increased deposit that will include this amount into the liquidated damage. Bear in mind that on residential, the maximum liquidated damage is 3%, or the initial deposit up to 3%. Okay, so just so you know, that's the reason, and you do want to include that form just to make your your transaction, I think, clean. Retention of deposit. So this again is referring us, like if we've been initialed for liquidated damages and those kind of the clause in the back of the contract. If you remember, I don't know if it's so prevalent now, but I think 15 years ago, there was a lot of countering where after the contingencies are removed, buyer shall release to seller the deposit, and the deposit shall become non-refundable. So what this paragraph is advising is that there is statutory language in liquidated damage requirements. So if you decide to write a clause like that, make sure you're consulting a qualified real estate attorney before adding a clause specifying a remedy, because if it's not worded properly and according to the requirements set forth in the civil code, it could be invalid. So before you start adding remedies, make sure that you're checking with our broker or management that will be, you know, that it's worded properly. Okay, so I haven't seen that going on much in these years, but way back, like I would say 15 years ago, you saw that a lot. Okay, so all cash offer, no loan is needed, of course. So the first loan in the grid section, the first loan is defaults to conventional unless you check seller financing, other, or FHA, VA. If you have an additional financed amount, it will also default to conventional unless you check other, seller financing, or VA. Okay, so if VA or FHA is checked, then that amendatory clause form FBAC needs to be incorporated and signed by all parties. This is a requirement for us to sign it. Now, if there is lender required repairs, you will know upon your inspection. So the RR form, request for repair, has now incorporated a section where you can add lender required repairs. Just bear in mind that the seller is not obligated to participate in those repairs unless agreed to in writing. But since it's a contingency of the loan, you may want to put your negotiating hat on and see what you can work out, because a lot of times those things can be worked out, just so you're aware. So balance of the purchase price and the down payment, the amount that the buyer will need to come in to close that escrow, towards close of escrow, will be on the first page of your escrow instructions. You will see the money that they're requesting to close it. And if you want closer to close of escrow, be talking to your escrow officer and ask them how many days in advance they need those funds there to hit your target close date. You know, and I would just want to stop for a minute, because there's so many things where we're saying, oh, check and do this and advise the buyer or the seller. And it might be a good idea to go through this contract and write a list, so that you have a list of items of things that you recommend that they check on. And that way they can go down like a punch list, a checklist. And I think it would be very helpful to all of the clients and to us as agents. So that's just an idea that maybe we can incorporate later and make some type of list. So limits on credit to buyer. So there is a section in the grid where you can request that the seller credit the buyer. That credit, that monetary amount, defaults to closing costs by contract, or you can check the box for other and insert what that will apply to. So that's called the contractual credit. But as I mentioned last week, whenever you're putting credits in the contract, please be checking with the lender, because there is a lender allowable credit. If you put 10,000 in there and the lender allowable credit will only be 8,000, when they get to closing, the buyers, they are only going to get an $8,000 credit unless you've agreed to prior to closing how that will be handled. There is no automatic adjustment to purchase price for the difference. So just make sure if you're putting credits in, your lender is so happy to be involved in your transaction in every way they can to help. So just be checking with them that that amount will be an allowable lender amount, and then you can adjust accordingly. So additional financing terms, so verification of down payment and closing costs, and verification of loan apps. So these are the pre-qual, pre-approval letter, and the proof of funds, as we call it, number A. So listing agents and buyers, you should include this in the offer. However, you could check a box to amend it to 3 days after acceptance, or amend those days to a different day frame. But your offers are much stronger if you come in out the gate and attach these documents. So generally, we've already reviewed those. Okay, so buyer stated financing, and those of us have been in the business have had this happen a time or two. So The seller relies on the buyer's representation of the type of financing specified in the contract when we accepted it. And they've agreed to that, buyer and seller. But if let's say a buyer checked for all cash and you didn't, and they just said they were going all cash, and then you find out later on in escrow that they are going to obtain a loan, the listing agent will usually find out because they're probably going to receive a call from the lender. So it's best to be open about these things. But if the buyer can go ahead and close within the time frame specified with alternative financing, then the seller should not interfere with that. So if you're in escrow and the money shows up and it's enough to close and on time, then great. But I would suggest that if you are switching, chances are the listing agent will find out. Maybe it's good to have a conversation about it first, because that's not a good feeling when you find out in the middle of a transaction. So closing in possession, the occupancy automatically, defaults to primary, but you also have two other options, secondary or investment property, that you may check. So condition of the property on closing, most of us have seen multiple counters that say the property is sold and it's as is present condition. Well, this is an as is contract already. So I just want to point that out where it says it. The property shall be delivered as is present physical condition as of the date of acceptance. So we still need to maintain the property, which they're saying here, in substantially the same condition as of the date of acceptance. Keep that water, that yard watered if you had it that way. Keep the grounds clean if it was presented that way when the offer was accepted. And here, all debris and personal property that are not included in the sale need to be removed by close of escrow or time of possession is delivered to buyer. So this is another thing that could be on our list. We want to be prepping the seller on how to deliver the property free of debris. We don't want paint cans or paint thinner or anything like that, because it's not something you can merely just throw in a trash can. So make sure you're prepping your clients for how to deliver the property free of debris and personal property. And if this is not done, there's a remedy section here that you can read about. If they leave property, a lot of times, which I've done, as I mentioned last week, if there's property, mounds of trash left, I've merely asked the buyer if they could accept a certain amount of money to get a truck over, and haul the trash. Sometimes that's the quickest, fastest way, as long as the seller signs off on that. Okay. So here, buyer is strongly advised to conduct investigations of the entire property to determine its present condition. So sometimes, the seller may not be aware that there's a leak under the house or things of that nature. They haven't crawled under there. So there's a lot of things they may not be aware of. So just make sure that you're directing your buyer to choose a home inspection company and termite company of their choice. So, and if they want to have a roof inspection, so whatever inspections they deem necessary to make themselves comfortable, including going to the city counter where the property is located and looking for permits and things of that nature. We should not be going to the city counters for the client, because if we hand them a stack and they think that everything's all inclusive and it wasn't, it's not good. So if they want to go to the city counter, direct them that way. Also, there are companies you can pay $75, $100 and they will go pull whatever permits they can find for you and deliver you a nice, neat package if they want to pay for that. Okay, so seller remaining in possession after close of escrow. This is the SIP form is a new form to the contract, seller to remain in possession. That form is used whether it's 1 day or 29 days. So the SIP is used for days 1 through 29 that the seller remains in possession. If they're remaining 30 days plus in possession of that property, then it is an RLAS, residential lease after sale contract. So make sure that if you see that it's 3 days after close of escrow, make sure you have a SIP in place and it's fully executed. At close of escrow, the seller assigns to the buyer any assignable warranty rights. So if you have warranty booklets on a refrigerator that's being left, dishwasher, things of that nature, or any assignable warranty, go ahead and provide that copy. Now, we may not know if it's assignable or not. So if they have a warranty book or a book of instructions, I always grab those and provide them. Sometimes they are booklets, so they're not easy to scan. So you can gather them up, put them in a nice, neat envelope, drop them off to escrow. They will provide those to the buyer or buyer's agent at close of escrow. So they have a nice package. Shoot an email off to the buyer's agent and let them know they are in escrow for them. So if the, okay, so the keys, remotes, codes to enter the property, mailbox keys. Even if the seller is remaining in possession, those keys need to be provided to the buyer upon close of escrow unless there is another agreement. So please make sure that that's being done, that you are having your seller organize the keys. You don't want to get like a big handful of 20 keys that you don't know what they belong to. So bring some key tags and you know, mention to them to get the keys tagged and in a order where we can turn them over. Okay, so if it's in an HOA, the seller is responsible for securing or providing any items for association amenities, facilities, etc. But the buyer may be required to pay a deposit to the homeowners association to obtain keys. So a lot of times you see they'll make you pay a fee for that to the gate to the pool. Okay, so contingencies and removal of those contingencies. So the buyer is advised right here to investigate the insurability of the property as soon as possible, because it is most likely going to be a requirement for the lender. And the buyer's ability to obtain insurance for the property should be part of the buyer's investigation, which in this contract, it defaults to 17 days after acceptance unless it's been amended. So if the buyer cannot obtain insurance for some reason, they may be justified to cancel the contract under the investigation contingency, but not the loan contingency. Okay, so very important. That's another thing for the punch list. Check for insurance. Buyers contractual obligations regarding the deposit, balance of down payment, closing costs, they are not a contingency unless otherwise agreed. So appraisal and loan contingencies, sometimes we used to think they were more interchangeable than they are. Yes, they go hand in hand to get a loan, but if you remove an appraisal contingency and that property and you still have your loan contingency and the appraisal came in low, you can't cancel the agreement based on the loan contingencies. These are independent contingencies. The appraisal is about the property qualifying for the loan, and the loan is about the buyers qualifying for the property loan. Okay, so those are separate contingencies. I know sometimes it's a little confusing, but they are separate. So just make sure that you understand that. Then this handles all of this. This is what I'm talking about here. If you don't have an appraisal contingency and it comes in low, you cannot cancel under the loan contingency. So Fair Appraisal Act, you'll notice this is a newer form and it's pre-checked here on number 3. It will auto-populate with your transaction. So everybody just signs the Fair Appraisal Act addendum. So investigation of property, it's contingent upon the buyer's acceptance of the condition of the property and any other matter affecting the property. So they may want to check the neighborhood, check some of the databases that we'll go over here in a minute. But any condition of the property, the buyer should investigate to make themselves comfortable with this transaction and going through with the purchase. review of the seller's documents. The seller, by default of this contract, should be providing the seller documents within 7 days after acceptance unless it's been amended. And it's contingent upon the buyer's review. They have 17 days unless you amended those days to review all the documents. So right here, they're talking about a title policy. So this agreement is, as specified, is contingent upon the buyer's ability to obtain a title policy on the property. So the seller's agent is normally going to provide you with a preliminary title report. So, and after the buyer receives it, they have the contingency period that was listed in the grid. If they've received it late, they have up to 5 days to review it. And or if they had any change to the prelim and sent you an amended prelim, you have 5 days to review that amended prelim, and if it's material affecting the property, as then you may have cancellation rights. So on the prelim, when you're reviewing it, agents, we should review it, but also your buyer should review it. You can request a copy. Some companies send it right away, but it'll be hyperlinked. So you could get a hyperlinked preliminary title report. So you're going to go through that title report, any of those blue hyperlinks, go ahead and click them and print those documents that appear on that hyperlink. And some of the old HOAs that people might not be aware of that are even on the property from the 20s, 30s, 40s, there may not be a hyperlink for those old disclosures. So you're going to need to call the title company and ask them to go ahead and provide you with those old HOA documents, because you do want to have a copy. You do want to deliver it to your buyer. Like I said last week, they may not be enforceable. You can have, the buyer can have legal counsel look at them, but make sure that you're obtaining them so that you are doing your best for your client. Also, there's another thing that you can get for free from the title company once you're in escrow. Usually there's going to be easements for utility companies. You know, that's pretty much a given on these residential properties. So if they didn't provide you one, you can request a plotted easement map, and they'll plot the easements for you on that lot, and they'll send it over to you. So that's another nice thing to be able to give to your buyer inside of the contingency periods, because you want to know where those easements are falling within the lot. Okay, so review of leased or lien items, contingency. I think we went over this last week, but I'll just mention again, solar panels, water softener systems, anything that's leased or liened. Make sure, listing agents, you're getting those contracts, you're getting that monthly payment coupon, all of those things, so that you can provide for the buyer so they can make an educated decision on whether they want to proceed. And bear in mind that if it's a leased or liened item, some of the solar panels could be $200 a month or whatever, you know, some are less, but make sure that the buyer is communicating with their lender, because that may impact the amount of a loan that they can get should that payment continue after the buyer owns the property. Sometimes you can negotiate and have it paid off through escrow. But again, like I said last week, even if something is paid off through escrow, you still may have contractual obligations with the company. So make sure that your buyer is reviewing all that and checking with the company that let that contract, so they understand what they're getting involved with. So the buyer doesn't have any obligation to remove contractual contingencies unless the seller has provided all the required documents, reports, etc. So if a buyer here removes or waives any contingency without an adequate understanding of the property's condition or the buyer's ability to purchase, they're acting against our agent advice. So contingencies, as Gregory was mentioning last week and asking about them, super important, because we want to make sure that we are, as I like to say, locked and loaded and ready to go before we're removing any contingencies. Really be double checking your file, make sure that the buyer is satisfied with all the inspections and things of that nature. check with your lender, make sure the appraisal came in, make sure the loan came in, loan is ready to go before removing. So do your due diligence. Your buyer will greatly appreciate that. Make sure you're checking with everybody before you're removing. Because at that point, when you remove all contingencies, you're locked and loaded on this and ready to go towards closing. So just make sure that you all understand it. Our clients rely on us so much because, you know, these are huge purchases and there's money in escrow. So let's make sure that we're doing all that we can and the best for our clients, which I know we all do here at Coldwell Banker George Realty because we're highly trained. So removal of contingency or cancellation. So if the buyer is through the contingency period, I'll just say 17 days as it defaults, and they still, and the listing agents made, you know, courtesy calls to the buyer's agent asking them to remove them, and it's getting, you know, serious, and the seller would like to provide a notice to perform to the buyer. So you need to perform, seller's agent, a notice to perform to the buyer, and it's a 2-day notice to perform. And if the buyer does not perform and remove the contingencies or contractual obligations, then the seller shall have a right to cancel this agreement. And I want to add in here, cancel the agreement, but also send that cancellation over to escrow and have them draw up their cancellation so that all parties can sign that as well. Okay, so the sale of the buyer's property, it's not a contingency unless it was checked on the grid section. There is a box to check for sale of the buyer's property. CAR form COP should have been attached if a buyer's agent checked that. If it's not, listing agents, make sure you're getting that prior to committing, because you want to see what the terms on the COP are that they filled in. So items included and excluded from sale. This is a super important paragraph. I love paragraph 9, but we also need to go over it and understand what is automatically included in a sale. Go over it with your clients as well, so that you understand it. So this is nice right here. Note to buyer and seller. Items listed as included or excluded in the multiple listing service. Sometimes you'll see things in the other remarks, or flyers, marketing materials, or disclosures are not included in the purchase price or included from the sale unless specified in that grid section. There's a paragraph 3P, or as otherwise agreed. 3P was that section where you could check what you wanted left with the property. So make sure that you understand that. If somebody made a mistake and included something in the other remarks, still check it on your offer. You want to put it in writing that that is included. And I really think that this is a good paragraph for us all to reread a few times. Every time I reread it, I'm learning something new. So just I'll quickly hit it. So all existing fixtures and fittings that are attached to the property, of course, are included, but window coverings, which includes blinds, curtains, drapery, are included. Water features and fountains are included. Light bulbs, including smart bulbs, are included. So make sure you're reading this. Make sure you understand what's included. Air coolers that are set in windows are included. Pool equipment down to the nets, if they have them, are included, pool nets. So make sure you understand what's in this paragraph. Go over it with your seller ahead of time so you know if they want to make any exclusions on the contract when an offer comes in. So and it says right here, if the seller does not intend to include any of these items, it could be not owned by the seller, or they don't wish to include them, or a stager or a third party place those items. Make sure that you are excluding those items. We want to exclude the drapes that maybe a stager put up, but make sure you're excluding those items. And there's additional paragraphs on security system, home automation, and non-dedicated devices, what is included in those. Leased or liened items and systems, we already went over that. Provide the contracts. Listing agents, you could certainly counter it into your contract so that everybody's aware, and make sure that they know that those leased or lien items are there and what the financial ramifications are of that leased or liened item. And here's paragraph C. items excluded from the cell. Flat screens would be excluded. Now we have kind of a newer thing. Up in the grid section, you can check to include the brackets which hold TVs or speakers or anything like that. You can check to include them, but if you don't check it, then they're excluded, right? So the seller would remove those components and repair the damage or holes in the walls or flooring, but not paint, well, not floor, excuse me, in the walls, but not paint. So just be aware of that. If you want those brackets left, make sure you're checking up and 3P in the grid to leave the brackets. Maybe they're a nice set of brackets and it'll work for you. So if you want the brackets, go ahead and check for them. Listing agents, just prepare your seller that if the buyer does not want the brackets, that you'll need to repair the holes or damage, but you don't have to paint. Okay. Allocation of costs. So I'm going to drop down to government requirements and corrective or remedial actions. So we have some required installations on properties, which are smoke alarms, carbon monoxide, strapping of the water heater. Okay, so that we need to do. And again, like we mentioned last week, if the seller, excuse me, has agreed to pay for these items and does not have them installed by the time an appraiser gets there, and it causes a reinspection fee because they now need to come out to make sure those items are done, then the seller is responsible for the buyer's cost. Excuse me. Point of sale requirements. As I addressed last week on the offer, normally a buyer's agent is going to check the government point of sale requirements. They're going to check it to the seller, excuse me, my voice. They're going to check it to the seller. Make sure you're not leaving these blank. I'm so sorry, I've been talking a lot since early this morning. So make sure you're not leaving those blank. And listing agents, make sure that you're checking with city, county websites, going to the city counter with your seller. Make sure you understand if there's a requirement for a point of sale, 9A reports in LA. So just make sure you're checking. Okay, so buyer's agents, you can go ahead and check those boxes because if they're not required, then that's fine. But at least you've covered in the offer checking those in case they are required. And after you put the offer out, if you want to do a little research, you can go ahead and see, check with the city, call the city, go to the counter or check on the website to see, just so you have a little bit of knowledge on that and see if there's anything required. Okay. So there's two prongs to the government. It's to requirements is the report, but also there is a checkbox for if there's any corrections needed, who's paying for that. So usually a buyer's agent will check both of those to the seller. Okay. Also the title companies will provide a list of what cities have requirements. So we can print some of those and leave them laying around the office for you to pick up. But even with a title company list, I still recommend that you do your own checking, your own research, and just make sure, okay? Because maybe something changed in a day or two. But so we'll print some of those lists and lay them around the office for you to take with you. So information and advice on the requirements. So right here it's saying that the buyer and seller are advised to seek the information from a knowledgeable source regarding local and state mandates and whether they are a point of sale requirements. So that could be your city counter thing, people like that I've noticed. And it also says that we do not have expertise as agents in this area, and we cannot ascertain all the requirements or costs of compliance. Okay, so back in the grid section, home warranty. So the buyer can check for home warranty or they can waive it right on the offer. We don't recommend that. Home warranty plans are wonderful. They add a little bit additional peace of mind for the buyer. So we do recommend it. So the buyer can decide what additional optional coverages they want and what company they want to go with. So agents, I suggest you contact your home warranty rep, go over the optional coverages that your client desires and the base plan, and make sure there's a box there where you can put a cost not to exceed on that home warranty plan. Make sure you're always filling that in. You don't want to be short on that, because if you are short, then the buyer's going to need to come up for the difference if you checked for the seller to pay. This is a negotiable item. Either seller or buyer or both could pay for it. Okay, so statutory and other disclosures. So we do have statutory disclosures. It's the TDS, SPQ. If you do a TDS, you also need to do an SPQ. If you're exempt from a TDS, the ASD, let me go over a couple of types of personnel that may be exempt from a TDS. We would like you to check with management first before you exempt a TDS. It's a very important document, but it could be, exemptions could be court-ordered sales, and Peter can address this or correct me, such as probate sales, foreclosure sales by a bankruptcy trustee. So, or if somebody died that owned the property, there's a lot of different things that could exempt people. So please check with us before you make an exemption on a TDS and don't supply it. We would rather answer your question. We can also call Car Legal Hotline and run the scenario by them. They're always happy to answer that. So another one is the NHD is a statutory requirement, and the fire hazard form. So I want to stop right here on 11A2. They're extensively going into the TDS and how to fill it out. So I am going to stop on 11.2, and I'm going to go into the TDS form just to go over very briefly some items that they're explaining right here in the offer. It's an extremely important document, so I just want to go over it really briefly. Okay, so here's the TDS, real estate transfer disclosure. It is a civil code requirement, a statutory disclosure. So up here, we all know how to do this: the city of, county of, and it's in the state of California, the address. And the date that I normally put here is when the seller has signed that, filled out this form and signed it, okay? Filled out this form and signed it. So that I matched that date. You can have the seller write the date right in here after they date their signature. So one of the things I want to point out that they explain in our offer is that all these sections must be completed. So coordination with other disclosure forms. You have three choices here: inspection reports completed pursuant to the contract of sale or receipt. So if you're attaching something like that, additional inspection reports or disclosures, you check that. It's one or the other, or the one that I think is most used is no substituted disclosures for this transfer. Doesn't mean you don't have your other disclosures. It's just that you're not, there's no substituted disclosures for this TDS. So make sure you're checking a box, because your TDS, as I explained right in the base of the offer, is not complete without filling this out. So coming down to 2, the seller's information. This is all the seller's responsibility to fill out. We don't fill it out for them. They're going to sign and date here. So coming down here to 3, this is also a requirement: agent's inspection disclosure. So this is for the seller's agent. This is for the buyer's agent. Normally in our brokerage, we recommend that you check see attached agent visual inspection disclosure, AVID. So you can just simply attach your AVID form, sign, the brokerage name would go here, you sign here. Buyer's agent, same thing. We do recommend that you check your AVID form and attach it. So down here, the very last signature here. So this is that the buyer and seller acknowledge a copy of this statement after everything up here has been completed. So once all of this is completed, Mr. Seller, Miss Seller, this has been completed. Could you please sign and date it? So you're going to want to have the seller sign and date once all of this is completed. If they've checked the attached AVID, make sure that those disclosures are indeed attached. So again, the date that I match up here not to be confused with when the form was fully complete, is the date that they fill out here. Because this is the date they're completing the form. This is the agent's work. And then down here, you're providing the seller and the buyer with a copy once all this is done up here, just to clarify, okay? Because that's what they're outlining in the purchase contract. So I'm now going to go back to the purchase contract. Okay, so here we are. Okay, we've already went over exemptions for the TDS, but again, please make sure you're checking first. So I want to point out number 4. If you send out a subsequent or amended disclosure, and it's highlighting some material facts about the property that could affect the property, the buyer has a right to review that. However, if it's something that they discovered, they are already aware, which the buyer is otherwise aware, and which was discovered by the buyer or disclosed in reports or document, then we don't have to amend or subsequently amend a TDS or something like that. So for instance, if their home inspector said, hey, there's a leak under the house, or there's a hole in the, garage back wall or something like that, you don't have to amend it because this was already discovered, okay? So I just want to point that out to you. Lead disclosures. So for any residential property built before January 1, 1978, this form is required unless they are exempted by law. Okay, so make sure that you are adding the lead-based property in for any properties built before January 1, 1978. And the home hardening disclosure and advisory, for any transaction where a TDS is required, we need to take a look at if this property is located in a high or very high fire hazard severity zone. We need to provide the home fire hardening disclosure. So C and D go together because it's home fire hardening and defensible space disclosure. This is one form. This is one form, CAR form FHDS. So this becomes applicable. If you note on your NHD report, it should tell you if it's in a high or very high fire zone. Also, if it's not noted on the MHD and the seller is aware that there was a huge fire behind their property, some kind of a big fire behind their property, they probably should fill out this form and provide it. So your NHD report will stipulate if it's in this type of high fire. But if you're aware that there was some kind of big fire near the property, you should probably provide that form as well. So we cannot waive any of the statutory lead-based or statutory disclosures, okay? So it's prohibited by law, just so you know. Return of signed copies. Buyer will return the signed copies of the disclosures within their contingency period or 5 days after delivery. So if you deliver them on day 17 and your contingencies are up, the buyer would have an additional 5 days. So get those done as soon as you can so that we're not extending contingency periods because we didn't provide them. Okay, so termination rights, I wanted to point this out. So the defensible space compliance, that FHDS form, there are boxes to check on the form. There are some new agents here. If we need to go over that in additional training, we've done it, but we can do it again. But it checks boxes of who's responsible for bringing that property into compliance if required. So if a lot of times the seller will check to the buyer, but at any rate, that form is provided. Now, if the buyer doesn't agree to the terms in that form, the seller can deliver and they don't want to sign it, they can deliver a notice to perform for the buyer to sign the agreement. And if the buyer still doesn't want to, and it's a 2-day notice to perform, they may cancel this agreement. Okay, so withholding taxes. So within the escrow instructions, there'll be a 593C form. That's for the California franchise taxes. And there's also FERPTA form. A lot of times the FERPTA form, the seller does not want that form out. They do not want it provided to the buyer. So how we take care of it is a qualified substitute, which you can have the escrow company or title company. We fill it out as best we can, and it's called a QS form. So once we fill that form out and we have escrow sign it and all parties execute it, then that steps in for the FERPTA, and it doesn't show the seller's social security number. The 593C form is something else that the buyer will need to be filling out. A lot of times they're asking us how to, the seller, excuse me, fill it out. I always refer them to their accountant because I don't want to be advising them on that. And, you know, I'm not a tax accountant. So it's best if they have questions like that to go ahead and to have them talk to a tax accountant. Recently, I had a gentleman, I referred him to an accountant because he did not want to exchange his SFR rental property. And he kept telling me, well, how much is it going to cost? How much is it going to cost in taxes? And I'm like, I don't know. So I finally said, I would like you to talk to an accountant. And I referred him to one. He paid him $75 and they got the 593 form filled out, 593C. And the seller was happy because he knew exactly what he was going to be paying in taxes. So we can't advise them on that. But there are accountants in our area. If you need somebody like that, let me know. I'll be happy to refer him. So he's a very good responsive accountant, and he'll fill that form out for your client. So Megan's Law, database and notice regarding gas and hazardous liquid transmission pipelines. So you'll notice here on both of these, they're providing them with a website where this information is contained. So neither the seller or the agent is required to check these websites. If the buyers want further information, the agent recommends that the buyer obtain the information directly from the website themselves. And during their investigation contingency period, we do not have expertise in these areas. Now, agents, please don't do the research for your clients. Let them look. Something may, seem important to them that you didn't think was important. Let them, please don't do it for them. Just direct them to these websites. They can check it on their own, okay? So that we don't have any issues, but you can highlight it and have them check those out on their own. Condominium plan development, we do need to let the buyer know if this is in any kind of HOA. So, and if that's the case, then within 3 days after acceptance, the agent, this listing agent needs to provide those HOA, order the HOA documents. And as we've said multiple times, those can take a while, so order those early so that we don't delay closing escrow or blow out contingency periods. Natural and environmental hazards. So we need to deliver to the buyer earthquake guide and environmental hazards booklet. We have these laying around the office for all of us. And for residential property containing 1 to 4 units, or any manufactured mobile home built before January 1, 1960, then if that's the case, you're going to need to complete and deliver the residential earthquake risk disclosure statement. So just bear that in mind. But in all of your transactions for residential, give them the booklet. There's a nice receipt at the back of the booklet you can pull out. They'll sign it that they received the booklet. Just put that in your file and remember to make that part of your disclosures. If the home was built before January 1st, 1960, then go ahead and complete the residential earthquake risk disclosure statement. Okay, So this is my last bullet for today. I cut it off a little bit so that I could end right at an hour, and it's worked out wonderful. So M is our last bullet that we're going to address in today's training, known material facts. So the seller needs to disclose any known material facts and defects affecting the property. So if they know of anything that known material facts on that property, make sure they're disclosing it. If there's any insurance claims within the past 5 years, they need to disclose that. They could even provide the buyer with permission to contact the lender. There's a CAR form for that. And also the seller is required to provide any other disclosures required by law. So just because they're exempt from filling out some forms doesn't mean that if they're not knowledgeable about some material items affecting the property that they should not disclose them. They do need to disclose. So with that, I'm going to wrap this session up. I ended right at an hour because I know it's a lot to absorb. So I am going to send it over to Peter to make any comments or any question.
Well, not much comment from me, but the last item to mention, the material fact, I want to mention that right now the Fhds, the fire hazard and defensive space is the main items, you know, and you have to if you know about this the property that's in a very high fire zone, you must disclose. And also you may mention that you know, you might the insurance premium would be much higher too than the other area, and also there might not be insurance company covering that. So that's some kind of material fact if you know about it. So that's important.
Oh, thank you, Peter. That's great. Does anybody have any questions for Peter or anybody else? Okay, so I think Anna had a question in regards to yeah, it appears that this is only required if the seller are non-foreign sellers. I believe you're right, Anna. Let me do a little bit of research and take a deeper dive on that. So she's asking the qualified substitute. It's required, it appears this is only required if the sellers are non-foreign sellers. Yes, I agree. So thank you for that question, Anna, and we'll look at the form together. Any other questions for Peter while we're here? Comments? Okay.
Very good.
Very good.
It's a good session again.
Yeah. So I want to tell everybody the same old tagline, you're never alone with Coldwell Banker George Realty. We have a wealth of knowledge in our company, and we're here to help you with all of your deals. You'll find the management team very responsive. We can get your questions answered. Call your manager, call Peter. We also have the CAR hotline, legal hotline. If you've never called the CAR legal hotline, it's a great resource for us. We pay through it through our CAR fees, and it's a wonderful source to use as well. So I wish you all a beautiful week, Win. It's my honor to be here with you today, and enjoy. Thank you so much, everybody.
Bye, everybody. Have a nice weekend.
Thank you, everybody. See you next time.
Thank you.